In Indian polity, we are going to discuss about basic structure of the constitution. Actually, in our original constitution, there is no term related to the doctrine of basic structure. This doctrine of basic structure came from the judgment of the Supreme Court in Keshavananda Bharati case 1973. So we have to know the evolution process of a basic structure through some famous cases. First case is 1951 Shankari Prasad case versus Union of India. This case was related to the right to property under Article 31. So the right to property Article 31, which was curtailed by the first Constitutional Amendment Act 1951. So coming to the 1951 first Constitutional Amendment Act. So in that time land reforms was going, and our government wanted to acquire more land from the jamindars and turn to those lands to the developmental programs or development purpose. Okay, so the first Constitutional Amendment Act 1951 added ninth schedule for the purpose of the land reforms. So the land reforms were added and were included in this ninth schedule by the first Constitutional Amendment Act 1951. And first Constitutional Amendment Act added two more articles, 31A, 31B. Okay, so 31A, 31B related to the effective land reforms, and this says government can acquire the property of people at any time. So coming to the Shankari Prasad case, in this case Article 14, 1931 were violated because Article 14 says equality before law, and Article 19 says protection of freedom of speech and expression, and Article 31 says right to property, which comes under the fundamental right. Okay, so in this case the Supreme Court ruled that, and it given the judgment called 368. According to 368 article, the Parliament has the power to amend any part of the Constitution, even fundamental rights also it can amend. And Article 13, actually Article 13 says a law which are inconsistent or derogation with the fundamental rights, it shall be null and void. This is the Article 13 actually. But the Supreme Court given the judgment under Article 13, there is a ordinary laws which comes under the Article 13, but not any Constitutional Amendment Act which not comes under the Article 13. So it was the judgment given by the Supreme Court. So finally it says, according to 368 article, Parliament can take away any part of the Constitution, even fundamental rights also. Okay. And the next case is a Golok case versus the state of Punjab. So in this case related to the Golok family, and he has 500 acres, and there were two sons, Henry and William, and as per his father, they will get 250 and 250 acres, they both, but the government says you will get only 30 acres from your father's side, and remaining acres will go to the government's control through Punjab Security of Land Tenures Act 1953. So we already said first Constitutional Amendment Act 1951, which was added ninth schedule for the land reforms. So according to 17th schedule, 17th Constitutional Amendment Act 1964, which was enacted by the Parliament, and it added some more state acts which comes under the land reforms in 9th schedule by the Parliament. And Punjab Security of Land Tenures Act 1953 also added in this 9th schedule through the 17th Constitutional Amendment Act 1964, and it said there is no judicial review for the subjects which comes under the 9th schedule. Okay, so in this case Supreme Court was distressed, and the Supreme Court said that fundamental rights are permanent and the Parliament can't take away or abridge any fundamental rights. Okay, so this was the judgment given by the Supreme Court in this Golok case, and again says and said Constitutional Amendment Act, which is also a law under Article 13. So if any law violates under Article 13, that it should be null and void. Okay, So again the Parliament enacted 24th Constitutional Amendment Act 1971, which amended Article 13 and 368. So it amended 368 article and it added 368 subclause 3. It says about fundamental rights can take away or abridged by the Parliament by using the 368 article power. So and again 13th article also amended by the Parliament through the 24th Constitutional Amendment Act 1971, and it added 13 subclass 4. Okay, so the law means only acts, regulations, rules, notifications, bylaws, but not Constitutional Amendment Act, which not comes under the Article 13. Okay. And coming to the Keshavananda Bharati case 1973, and we can call it as a fundamental rights case also, and a basic structural case also. So in this case Article 26 was violated. So what is Article 26? Article 26 is managing of religious institutions. So in this case the Supreme Court given the judgment called, according to 368 article, the Parliament has the power to amend any part of the Constitution, even fundamental rights also it can take away or abridge. But it given the judgment called new doctrine, it was added. So the new doctrine called basic structure. Without touching the basic structure, you can take away any fundamental right. This was the judgment given by the Supreme Court in this Keshavananda Bharati case 1973. Okay, and coming to the 1975 Indira Nehru Gandhi case, and the Parliament enacted 39th Constitutional Amendment Act 1975 through election disputes of President, Vice President, Prime Minister, Speaker of Lok Sabha. There is no interference of the courts in these disputes. So there is no judiciary review in the election disputes related to the President, Vice President, Prime Minister, Speaker of Lok Sabha. Actually, this 39th Constitutional Amendment Act 1975 against the free and fair elections. Okay. Actually, judicial review is also one of the basic structure, and Supreme Court said through 39th Constitutional Amendment Act 1975, the Parliament behaving overpower in the point of amendments. So the Supreme Court said this 39th Constitutional Amendment Act 1975 is invalidated. Okay, and Parliament came with the 42nd Constitutional Amendment Act 1976, and it amended the 368 article itself, and two important features under 368 article amended by the 42nd Constitutional Amendment 1976. What is? It means no limitation on constant power of Parliament, and there is no amendment which come by the Parliament. There is no question on this amendment in courts, even from the point of fundamental rights controversy. Okay, and next case is Minerva Mills case 1980. So the Supreme Court invalidated that provision under 42nd Constitutional Amendment Act 1976, and a judicial review also excluded. Okay, because judicial review excluded, the Supreme Court invalidated this provision, and Parliament has the limited power under Article 368. This is also one of the basic feature. And coming to the 1981 Woman Rao case, the basic structure will apply to the Constitutional Amendment Acts which are enacted after 24th April 1973. The date of judgment given in the Keshavananda Bharati case will apply after 24th April 1973 cases. Okay. So, coming to the elements of the basic structure of the Constitution. There were 20 elements. First one is supremacy of the Constitution, sovereign democratic republic nature of the Indian polity. So, these are the basic structures. And according to 368 article, the Parliament has the right to amend any part of the Constitution and without affecting basic structure. So the parliament has no right to affect sovereign democratic republic nature of the Indian polity. And the third one is secular. Fourth one is separation of powers between legislative, executive and judiciary, and federal character of a constitution, unity and integrity of the nation, welfare state, judicial review. Okay, judicial review is also one of the basic structure, and a parliament has no power to touch the judicial review. And freedom, dignity of the individual, parliamentary system, rule of law, balance between fundamental rights and directive principles of state policy, equality, free and fair elections, judiciary independence, limited power. Okay, 16th element is very important. A limited power of parliament to amend the constitution is one of the basic structure of the constitution. So the parliament has a limited power in the point of amending. Justice, effective justice, fundamental rights, powers of the Supreme Court related to the 32, 136, 141, 142 articles, and powers of the High Court 226 to 27 articles. Okay, these are the basic elements. And one more thing is, according to 44th Constitutional Amendment Act 1978, the right to property, Article 31, was repealed under fundamental rights. Okay.